Hi, everybody. Welcome back to Aux Talks and another episode of Stay Out of Court in my continued endeavor as a active practicing lawyer, litigator in California. I'm trying to do my best for 30 years of doing this to provide you guys some general guidelines and some information that will hopefully help you make better decisions with the goal of staying out of the legal system, staying out of court. Obviously, I'm not giving you specific legal advice on this channel. You have to go see your own lawyers, your own advisors. Laws vary from state to state, jurisdiction to jurisdiction, country to country, obviously. So go see your own lawyer. But a lot of these things I'm trying to give you in these episodes is pitfalls, things I've run into, things I'm seeing actively in my legal profession day to day. Today, I want to discuss with you the concept of force majeure. It's force majeure, M-A-J-E-U-R-E. Okay, it's a French term, and what its literal definition is superior strength. Okay, the dictionary definition of force majeure, according to Oxford, says unforeseeable circumstances that prevent someone from fulfilling a contract. Let me repeat that. Unforeseeable circumstances that prevent someone from fulfilling a contract. That is the first segment of the definition, or the first definition they give. The second one is irresistible compulsion or greater force. Doing contract work over my whole legal career, I have seen various iterations of force majeure clauses. You hear of them being referred to as acts of God. But since the pandemic, I've been seeing this come up much more frequently in contracts. Doesn't matter what kind of contract it is. It could be real estate. It could be a contract to buy or sell a business. A lot of times you see it with regard to when you're ordering goods or services, something's being custom built for you. Maybe you use these clauses in some of your own contracts. But what I want to do is discuss it with you today because it's something you need to be aware of. Usually these force majeure clauses are at the end of the contract under miscellaneous terms and conditions. They're normally, I don't say buried, but they're definitely usually at the end of contracts, which most people do not read, do not understand, and do not discuss with their counsel before entering into an agreement, all right? Whether you're receiving a benefit or whether you're conferring a benefit on somebody else. These cut both ways, all right? So I don't want to do a long video today, but I want to discuss a force majeure with you. So I want you to keep it in mind. And I pulled up just a couple of examples of force majeure clauses that have from online, and I have one specifically in front of me that just came across my desk in the last few days, and I'll read that one to you too. I want you to get a flavor for how these things are worded because they're very broad in scope. And now, post-pandemic era, we had a lot of people trying to let's say enforce these force majeure clauses in order to either get out of a contract, either to not have to perform, right? Whether they were conferring a benefit or receiving a benefit, okay? It's a way that people try to use, or a method people try to use to break a contract, right? But the language is always very susceptible now to multiple interpretations, okay? And so it becomes one big gray area. When is it actually an act of God? When is it deemed unforeseeable? And of course, post-pandemic, you have a lot of this coming up now, where contracts were breached and those clauses were used as either a sword or a shield. Okay, so let me read one to you I pulled up. This is just off of Google. Force majeure. No party shall be liable or responsible to the other, nor be deemed to have defaulted under or breached this agreement for any failure or delay in fulfilling or performing any term of this agreement, except for any obligations to make previously owed payments to the other party hereunder, when and to the extent such failure or delay is caused by or results from acts beyond the impacted party's reasonable control, including, without limitation, the following force majeure events that frustrate the purpose of this agreement. First, acts of God. Second, flood, fire, earthquake, or explosion. Next, war, invasion, hostilities, whether war is declared or not, terrorist threats or acts, riot or other civil unrest. Next, government order or law. Next, actions, embargoes, or blockades in effect on or after the date of this agreement. Next, action by any government authority. Next, national or regional emergency. Next, strikes, labor stoppage or slowdown or other industrial disturbances. Next, epidemic, pandemic, or similar influenza or bacterial infection, which is defined by the United States Center for Disease Control as virulent human influenza or infection that may cause global outbreak or pandemic or serious illness. That's a mouthful, right? And what wouldn't fall in that category? Next, emergency state. Next, shortage of adequate medical supplies and equipment. Have you heard that one before? Next, shortage of power or transportation facilities. And lastly, other similar events beyond the reasonable control of the impacted party. Of course, the catch-all, conclusory language. So that is an example of the force majeure clause that I just pulled off of Google. Obviously, it's pretty far-reaching. So if you, let's say, extrapolate that, how many situations could arise in any given, let's say, short-term period of time that somebody could use it to try to get out of a contract, or not perform it the contract, not pay you, not fulfill an order, whatever it is. So I want you to keep that in mind, because contracts are, they're negotiable, meaning once you sign a contract, guess what? It's not negotiable. But I've had clients come in to me with contracts where we have these broad, sweeping force majeure clauses, and I will, I'll take a scalpel to that language and say, look, you can accept this if you want it, but here's what I'd recommend, and then you tighten it up as best you can, so it's not just blanket gray area, subjective, right, definitions and clauses. So that was one that I pulled off of Google. Here's one that came across my desk on a contract I'm actually looking at. And it says it's entitled COVID-19. It says, in the event that the name of this business shall be liable for any non-performance, delay in performance, or any other variation from seller's performance obligations, nor for any loss, let me back up. It says, in no event shall this provider be liable for any non-performance, delay in performance, or any other variation from seller's performance obligations, nor for any loss or damage to any goods supplied to buyer when directly or indirectly by any cause beyond the reasonable control of seller or its suppliers, vendors, subcontractors, or other representatives or agents, including but not limited to communication line failures, power failures, natural disasters, disease, pandemic, or acts of God, acts of criminals or public enemy, war, riot, official or unofficial acts, contracts, regulations, or restrictions of any domestic or foreign government agency, acts of buyer or its employees, representatives or agents, strikes or labor difficulties or failures, shortages or delays in seller's usual sources of labor or materials. And it says that this supplier shall automatically be entitled to a reasonable extension of all periods of performance when delayed by any such cause. Again, they sneak in the word contracts, performance of the other party, all these things that really have nothing to do with a completely unforeseeable, let's say, act of God. Okay, so they start to legal, lawyers get fancy and start to basically just make this language all-encompassing, right? It almost gives these parties, that language is horrible, right? But someone signed that contract, and someone is bound by the terms of that contract if it were to be used against them, all right? So please be careful with force majeure clauses before you sign contracts, not after. Go see competent legal counsel, contract counsel, have them look at the clause, make sure that they're not being phrased as these catch-all scenarios that could, really end up with or wind up having you in court and having to use the legal system in this country for any kind of damages or whatever injury you might suffer through one of these clauses in a contract that you didn't read, you just simply signed off on. I'm not saying all contracts are fully negotiable. Some contracts are adhesion contracts, and the buyer or seller, the other party says, hey, take it or leave it. And you got to decide, is it worth walking away from whatever the contract is that I'm being asked to sign. I'll leave it there today. It's about 10 minutes. Hope you got something out of this. please subscribe to the channel. We do these Stay Out of Court series, but also cover, as you know, economics, some politics, law, a whole host of things. So I appreciate you guys supporting the channel. Please like, share, subscribe. Talk to y'all soon. Bye.